January 10th, 2019. The judge in the murder for hire case has a sense of humor. On January 3rd, the judge Scott L. Palk ruled against Joe Schreibvogel's motion to dismiss counts 3 through 11 of his tiger trafficking charges, stating that he owned the tigers before the rule went into effect to restrict the interstate commerce in tigers. That rule was the Generic Tiger Loophole that we successfully closed on April the 5th of 2016. The judge ruled that possession of the tigers, or anything that he did with them prior to that date, wasn't at issue, as these were all current allegations. Yesterday, the judge ruled against Joe's motion to dismiss counts 1 or 2 regarding hiring a hitman to kill me. The court summarized. The court's references to these counts as murder for hire counts, herein, instead of the wordier use, and this is in quotes, use of interstate commerce facilities for purposes of murder for hire counts, unquote, is not meant to diminish the government's requirement of proving the use of an interstate commerce facility in relation to the alleged offenses, as well as each count's others elements, care, exhibition, and breeding of tigers and lions that, in February 2013, resulted in a civil judgment against the defendant of more than $1 million. Carole Baskin and related business entities have attempted to collect the judgment from defendant and his related business entities ever since. In the first murder for hire count, the government alleges that the defendant inquired of Individual 1 in November 2017 whether Individual 1 would travel to Florida to murder Carole Baskin for a sum of money that defendant mailed a cell phone and that defendant mailed a cell phone to another state to conceal Individual 1's involvement in the plot. The government also alleges that the defendant gave $3,000 to Individual 1 in November of 2017 in exchange for his agreement to travel to Florida and kill Carole Baskin. In the second murder for hire count, the government alleges that from July 2016 to March 2018, defendant asked Individual 2 if he could locate somebody to kill Carole Baskin for payment. The government further alleges that in December 2017, Individual 2 offered to introduce and then introduced defendant to an undercover FBI agent posing as a hitman who discussed with defendant the murder of Carole Baskin for payment. The superseding indictment continues. From December 2017 to March of 2018, defendant allegedly spoke with Individual 2 by cellular phone regarding the murder of Carole Baskin, but the government does not allege that the defendant interacted with the undercover FBI agent directly after a single face-to-face meeting in December of 2017, which was recorded by the government. All of the defendant's remaining interactions are alleged to have been with Individual number 2. Nor did defendant supply money or anything of pecuniary value to the undercover FBI agent. The judge then had to chuckle to himself as he wrote this in response to Joe's attorney's best efforts. Further, defendant's proposed interpretation of Statute 1958A necessarily fails when the statute's text is evaluated in toto. The another referenced in relation to the use of interstate commerce facility can be, per the statute, the intended victim. Applying defendant's approach to a situation where the another is the intended victim, a person could only be guilty of violating Statute 1958A if he or she caused an intended victim to use a facility of interstate commerce with the intent of murdering himself or herself in exchange for payment to the same intended victim. Such a fact pattern is nonsensical. Unless the court deletes including the intended victim from the statute, which the court will not do, defendant's interpretation cannot prevail without creating an absurdity within the statute. The judge also referenced this testimony. The transcript of a discussion between the defendant and the undercover FBI agent, excerpted in the government's response, to which the defendant raises no objection, creates at least a dispute about whether this evidence, and any other evidence presented at trial, will show a violation of Statute 1958A as alleged in Count 2 occurred. At the face-to-face meeting, defendant apparently asked about the price of a murder and how much would need to be paid up front, said, quote, we'll get game with the money, unquote, and, quote, we can get $5,000 easy, unquote, and affirmed that he could come up with an upfront payment of $5,000. Resp 6, Doc number 47. Per the government's transcript excerpts, defendant also replied, quote, okay, unquote, to the undercover FBI agent's suggestion that he meet him again once defendant, quote, got those two phones and the money together, unquote. The judge concluded that both counts would be considered, and that's good because each can carry a 10-year sentence. If you're enjoying my diary, please like, share, and subscribe. You can find other ways to connect to me over at bigcatrescue.org/Carole.Baskin.